Hi everyone, and welcome back for another episode of Malice in the Mitten. I'm your host, Tracy Preston, along with my bestie, Christine Mulligan. Hey, Christine.
Hey, Trace. Hey, everyone. First and foremost, I want to say Happy New Year.
Happy New Year.
Happy New Year to everyone listening, too. I cannot believe we have so many listeners now. It's crazy.
It's amazing. I love it. Love it, love it, love it. We're just getting our foothold here, and we have a big library, so come and have a listen.
Yeah, we have a lot out there already. It's just bonkers. Anyway, all I do is I feel like we're just chit-chatting, you're telling me stories. And then I remember, oh yeah, we're recording this for everyone.
That's the beauty.
It's still wild. So anyway, we finished up our little trilogy about women and crime and the history and all that. So what's going on now? What are you telling me about?
Well, in today's episode, we are dealing with another case that has not received justice in a decade. It seems like we've had a lot of these lately. And it makes me wonder, is 10 years the magic number? All I know is 10 years to the family and friends waiting for justice. That time must feel like an eternity in purgatory. Now, we have a lot of ground to cover here, so let's dive in. This is Season 10, Episode 13, Danielle Stislicki, the parking lot, the tip, and the evidence war. A parking lot at 5 o'clock on a Friday. The kind of ordinary place where nothing is supposed to happen, because everything is happening everywhere else. Phones are buzzing, headlights blinking on, people thinking about dinner, errands, weekend plans. And then a woman walks out of work, gets into her vehicle, and disappears from her own life. Her name is Danielle Stislicki. She had plans that night. She never made it to the table. And nearly a decade later, this case is still fighting over time, over proof, and over what a jury may never be allowed to hear. Now, quick note before we begin. This episode involves an unsolved disappearance and allegations tied to sexual violence in a separate case. And we will discuss court proceedings and publicly reported information. If you or someone you love needs support, please check the episode notes for resources. And, as always, until a verdict is reached in court, charges are allegations. We will be careful with language because words matter. Danielle Stislicki, Dani, to those who loved her, was the kind of person friends describe in the way they describe sunlight. The type who keeps plans. The type who answers texts. The type who shows up. And when a person who is consistent suddenly breaks pattern, the silence means something. Before Danielle Stislicki became a case file, before her name appeared on flyers and court dockets, before Michigan learned to say missing since 2016, she was simply Dani. She was born on February 28, 1988. She was 28 years old and lived in Farmington Hills in the Southfield area, which is Oakland County, Michigan. She worked at MetLife. Her life existed inside ordinary routines, the kind most of us never think twice about. Friday, December 2nd, 2016, Danielle Stislicki wakes up in Farmington Hills, Michigan. It's not a special day. It's not a holiday. There's nothing circled on the calendar that marks it as different. She gets ready for work. She leaves her apartment. She drives to Southfield, the same roads she's driven before. Dani goes to work. She does her job. She talks to coworkers. The hours pass the way they always do. Measured, predictable, forgettable. Later that evening, she has plans. Dinner plans. She's meeting a friend, not a maybe, not a we'll see, a plan solid enough that someone is waiting for her. At around 5 o'clock, Dani leaves her office. She walks through a parking lot she's walked through before. She heads to her car. She's thinking about her evening, not about danger, not about fear, just dinner. Somewhere between her workplace and the restaurant, between see you later and I'm on my way, Danielle Stislicki disappears. Because when someone like Dani disappears, the absence is loud, precisely because her life was consistent. And when she didn't arrive, concern wasn't delayed. Her friend didn't assume Dani got busy. She didn't assume she forgot. She didn't assume she changed her mind. She knew immediately that something was wrong.
Well, based on all the things you just said, Dani being someone who was consistent, her absence just didn't make any sense.
Exactly. People who disappear by choice usually leave confusion behind them. Dani left alarm. The next morning, Dani's black 2015 Jeep Renegade was found parked outside her apartment complex, just feet from her door. Her purse was inside, her identification, her credit cards, everything she needed to move through the world left behind. There was no packed bag, no note, no signal that she intended to step away from her life. And this matters because the most powerful testimony about who Dani was doesn't come from headlines. It comes from what she didn't do. She didn't cancel dinner. She didn't stop answering her phone. She didn't walk away from her home. Public records describe Dani physically. She was 5 feet 5 inches tall and weighed 123 pounds. She had brown hair and brown eyes, and she also had a few tattoos, but those details only tell part of the story. Her tattoos? She had a koi fish on her hip, a constellation on her shoulder, a phoenix on her lower back, and candy peanuts and popcorn on her foot. The artwork she put on her body suggests someone expressive and with meaning. Now, these tattoos showed that she was someone vibrant and uniquely herself. Her smile, her plans, her ordinary human rhythms are the things missing from the world she left behind. She wasn't someone fading out. She wasn't someone erasing herself.
Well, just the phoenix on her back alone. The phoenix is about survival, coming through something and emerging, about rising.
Right, about rebirth.
Yeah.
Coming out of the ashes. I love that. And that symbolism has stayed with people who remember her. Now, there's something investigators always return to when a person vanishes, and that's their routine. Not just habits, but reliability. Danielle Stislicki was reliable. She answered messages. She showed up. She didn't disappear mid-conversation, and that's why the moment she didn't arrive at dinner, alarms went off immediately. Her friend didn't wait overnight. She didn't assume Dani got busy or changed plans. She knew something was wrong, because cases like this are often lost in the gap between maybe and missing. But Dani didn't give people reason to doubt her absence, and I just have to say, good on her friend for immediately knowing something was wrong and taking action.
Yeah, well, obviously, Dani was the kind of friend that she earned the people around her. She earned their trust, and she was consistent, like I said before. So someone who earns your trust like that over the years, I mean, you're going to notice when they veer from their patterns.
Exactly. And it's why this case moved fast at first. Law enforcement wasn't looking at a runaway theory. They weren't treating this like a misunderstanding. From the beginning, this was treated as a disappearance under suspicious circumstances. And yet, despite urgency, there was no public crime scene. No screams were reported. No signs of a struggle found in the parking lot. No broken glass. No abandoned phone. Just absence. Which brings us to the most chilling part of this case. Dani didn't vanish in isolation. She vanished in plain sight. Now, in the days and years that followed, Dani's name didn't disappear. Friends and family shared her photo, and the hashtag #FindDani spread through Michigan on social media in an ongoing effort to keep her story alive from people who knew her or knew of her still remember her face and her name. She was someone people cared about locally. Vigils were held, posts resurfaced year after year. This wasn't a case people forgot how to talk about because Dani wasn't a stranger. She was someone's daughter, someone's friend, someone who was expected to walk back through her own door. And it's important we say this clearly. Danielle Stislicki is not defined by how she vanished. She is defined by the life that was interrupted, by the Friday night dinner that waited, by the apartment she never entered, and by the routines that ended mid-step. There was a woman who left work thinking about her evening. That's who Dani was. And that's the version of her that we carry forward as we step into the parking lot. When Dani walked out of her workplace that evening, nothing about her day suggested it would be the last time anyone saw her. And yet, what happened next would turn an ordinary parking lot into the center of a decade-long search for answers. There is no evidence she planned to leave her life behind. No message sent, no goodbye written, just a normal day, ending without an ending. This is not a story that begins with violence. It begins with routine, and that may be the most unsettling part of all. Now, the next morning, her Jeep is discovered parked outside her apartment at Independence Green. Her purse is inside, as I mentioned, along with her ID and credit cards. Her vehicle is locked, but Dani is missing.
But that detail alone, that kind of makes your stomach drop. Because she leaves work and she's on her way to dinner. But somehow her car ends up feet from her door with her purse inside, but she's not. And to our knowledge, there were no plans for her to even go home after work. She was going out to dinner to meet a friend. They were waiting for her already, right?
Exactly. Because if you're planning to meet someone for dinner, your purse doesn't usually stay behind.
Well, it doesn't stay behind, but also your car doesn't end up back at your house instead of at the dinner place. So that's super confusing. I'm already intrigued and baffled how her car, she leaves work and somehow her car ends up back at her house with all of her stuff in it and no sign of her. And then you did also mention that there's no signs of her going back into her apartment.
Right.
So are we getting more into that?
Yeah, there's a lot that's still coming.
Okay.
I'm going to say a purse is a strange thing. It's not an accessory. It's not something you just carry. It's where you keep your way through the world, right? So your ID, your money, your keys, your phone, your ability to move forward. Like, we put everything. I know I do. The bigger the purse, the more shit I put in it. Now, Dani's purse wasn't missing. It wasn't stolen. It wasn't tossed aside in anger or haste. It was just sitting inside her Jeep, waiting.
When you carry a purse, you definitely don't leave your purse behind when you're getting ready to go anywhere. And you normally don't ever leave it in your car, even if you're parked in front of your house. You normally always bring it in the house.
Exactly. Now, I've done this once or twice. I'm in my driveway and I've got my bag in there and I'm like, shit, I forgot whatever. My phone's still sitting in the house. And I go to get out of the car and I'm like, it feels weird because I've made the decision to leave my purse in the car and I'm in my driveway. But it felt weird. But I'm like, it's all right. I'm just running in real quick. I'll be right back. But maybe there wasn't a choice as to why she left hers there. Investigators also didn't find evidence that Dani packed anything. Like I mentioned, no bags. She didn't have any clothing that was missing. She didn't have any sign that she intended to disappear. Instead, they found tools of daily life left exactly where they had always been. And sometimes that tells you more than anything that's gone. Now, because disappearances by choice usually leave preparation behind, disappearance by interruption leaves objects like a purse in a car, a phone that stops being answered, a dinner reservation that never fills. The purse doesn't tell us what happened to Dani, but it tells us something just as important. She expected to keep living her life, and that expectation never came home. Here's what multiple outlets and court summaries converge on. Dani's last seen leaving her workplace at Raleigh Office Center complex in Southfield, and witnesses place her interacting with a man who worked security at the building. Court records describe the scene as a man beside a vehicle with his hood up, like he's having car trouble. Dani is seen nearby talking to him, and then a co-worker reports seeing that man in the passenger seat of Dani's Jeep as it's exiting the lot.
Which, if that's true, means she didn't just vanish, she left. And she left with someone in her car.
Yep, that's one of the central prosecution theories, and they point to additional threads, like cell phone activity, suggesting her phone communicated with towers near this man's home later that night. But it's also where this case begins to split into two realities: the story investigators believe happened and the evidence they're allowed to use to prove it. Because years into the investigation, a judge ruled that multiple pieces of evidence, some of the most talked about evidence, will not be shown at trial. And to understand why, we have to talk about a tip. But before we do, I just want to say something more about the parking lot theory. Now, parking lots are transitional spaces. No one stays long. Everyone's distracted. And that's why they're dangerous. According to court filings and testimony summaries, multiple witnesses place a man in the lot that evening. Someone Dani would have recognized. Not a stranger lurking in the shadows. A co-worker. A security guard. Someone whose presence didn't trigger alarm. Witnesses describe what looks like a breakdown scenario. Hood up, car trouble, a universally human moment. One that invites help. And here's the thing about people like Dani. They help.
Yeah, I think most women would, especially coworkers. It's almost like women are conditioned. It's just what we do.
Yeah, and especially when the request comes from someone you already know.
Yeah.
One witness later reports seeing this man in the passenger seat of Dani's Jeep as it left the lot. Now, if true, and again, this is what investigators allege, it suggests Dani didn't leave voluntarily in the sense people imagine. She didn't choose danger. she chose normalcy. She chose courtesy, and that may have been enough. Now, onto that tip. Public court summaries describe it like this. On December 9th, 2016, a police chief receives a call from a longtime friend, someone connected to law enforcement work, who says he has information about a security guard and a homicide, but only if his identity is protected. The chief relays the information to Farmington Hills police leadership. Now, what matters is not just what the tip said, but where it came from. Now, according to the Michigan Court of Appeals summary available publicly, the source of the tip was tied to a polygraph operator who worked for defense attorneys, and the information was considered privileged, meaning protected in a way the government isn't allowed to exploit. The tip, again, as summarized publicly, described actions allegedly after Dani vanished, including where items might be discarded and where a cab might be involved. And investigators acted quickly.
So essentially, this tipster provided a roadmap.
Yeah, and that's the issue. Courts later looked at whether law enforcement and prosecutors knew or should have known the tip was privileged, and whether continuing to use it violated due process. And here's the result that shaped everything since. A trial court determined the government violated due process and ordered suppression of evidence derived from that tip. And appellate litigation has revolved around that suppression. Now let's translate suppression into plain language. It can mean investigators may have found something real, something meaningful, but the jury might never hear it because of how the trail began. Now, in July of 2025, reporting outlined specific categories of evidence a judge ruled would be suppressed, meaning not presented at trial. Among those publicly listed is Dani's Fitbit and any evidence derived from it, and her car keys, including references to where they were found. Tim Horton's evidence from December of 2016, including surveillance video and certain phone records. Information from a BP gas station at Grand River and Halstead, including surveillance of the defendant walking past at a reported time that night. Cab company information, including a driver's testimony and ride records. And specific retail bank threads, including materials connected to a Bed Bath & Beyond purchase and certain bank records tied to how investigators learned of that purchase. Suppressed evidence can be real and accurate, but still excluded if obtained improperly.
So that's a lot of suppression. That's a lot of information that's being suppressed. So it's almost like truth doesn't really matter. The truth doesn't always equal admissible, which to me personally is an insane concept.
It truly is, but I'm going to explain something about that. It makes me angry because there's a lot there, and this is one of those hiccups that happen, right? They ran with it because they're like, oh my gosh, this is taking us somewhere, but it's how they got that information, which is really sad. Now, it matters because the public has heard about some of these points for years. Items found, movements tracked, the idea of a timeline after she vanished. But in court, what matters isn't what the public has heard, it's what's admissible. And in this case, that admissibility fight is tied to the tip's privileged origin, what courts call the fruit of the poisonous tree. If the tree is illegal, the fruit cannot be served.
I hear that and I get that, but my thing is things like phone records and video of the victim. I mean, those are timeline things that should never be suppressible. It's almost like personal data. You know what I mean? Like, if something happens to your person, but your person left behind tangible data like phone records, or you stepped in front of a camera anywhere USA, I feel like those things should always be allowed to be looked at. I don't know, but that's just me coming from an emotional perspective. I hear you. The law doesn't always make sense to me at all. So I digress. Go ahead. Tell me more.
I know. I'm right there with you. It just, in the pit of my stomach, it just makes me sick. Now let's slow this down a little bit, because this is where many listeners could get lost. You might hear that evidence was suppressed and think it means it was fake or wrong or unreliable, but that's not what suppression means. Suppression means the evidence may be real, may be accurate, and maybe even devastating, but the path used to obtain it violated constitutional protections. In Dani's case, the courts examined whether law enforcement used information that was legally privileged information that they were not entitled to act on. And if that initial setup was illegal, then everything that follows it can be poisoned. So again, the fruit of the poisonous tree means the tree is the illegal act, the fruit is everything that grows from it. And in this case, the fruit allegedly included location data, surveillance video, wearable tech evidence, and physical items. So if people say, well, how could they lose so much? The answer is they didn't lose it. They're not allowed to use it.
But that's my point. That's my point. Especially the things that you just said. You know, location data, surveillance video, wearable tech evidence, physical items that belongs to the missing person, so AKA victim, for all intents purposes. I don't think that any of that should be connected to a poisonous tree, because automatically I'm already thinking the person that gave this information or the person that went with the story intentionally may have done that because they knew by doing it in that fashion that none of it would be allowed to be used. Do you know what I'm saying? Like, I smell
a rat.
I smell something foul in the water, is what I'm saying.
Yeah, I'm with you. As I was reading that, that's exactly the thought process that was going through my mind. Like, this guy works for defense attorneys.
Exactly.
Mm-hmm.
So the thing is that he knew what he was doing in the first place.
Yeah.
He was poisoning the roots of that tree that bears all the other fruits that technically belong to the victim. Those are all, I don't know, it's almost like, it's almost like HIPAA to some extent. Like, after the patient dies, all bets are off on HIPAA until you figure out what happened to that patient when things go awry, is what I'm saying.
Yeah.
I don't know. I don't know. I'm annoyed at that.
Yeah.
So I'll just shush and you keep going.
Yeah, I'm highly annoyed, and many people are as well. Now, the man charged in Dani's case is Floyd Russell Galloway Jr. Now, in 2019, Michigan's Attorney General announced a first-degree premeditated murder charge in connection with Dani's disappearance. But by that point, Galloway was already serving a prison sentence for a separate 2016 attack on a jogger involving kidnapping and sexual assault-related charges. Now, important legal guardrail here. That separate conviction is not automatically proof of guilt in Dani's disappearance. It may shape public perception, but courts treat cases by evidence, and there have been legal battles over what, air quotes here, other acts evidence can be introduced. The Michigan appellate records show litigation over whether evidence of that prior assault could be used in the Dani trial context.
Yeah, so this is where the court basically saying, you don't get to argue, he did that, so he did this.
Exactly. The legal system is built to prevent convictions based on propensity, on bad person logic, rather than proof beyond a reasonable doubt in this case, which means prosecutors have to build the Dani case on what survives suppression, what survives motions, and what survives appeal. And that leads us to the long, grinding road toward trial. Now, before we continue, a brief content note. The next portion of this episode discusses a violent assault against a woman who survived. While the details are not graphic, the segment includes description of physical restraint, strangulation, and sexual violence. This section is told to center survival and context, not to sensationalize harm. Now, if this content is difficult for you, please take care of yourself. You may skip ahead several minutes or pause and return when you're ready. Now, I will have support resources listed in the show notes. Now, before there was a murder charge in Dani's case, before years of hearings and appeals, there was that other woman, the one I just mentioned regarding the kidnapping and sexual assault. In late summer of 2016, weeks before Danielle Stislicki disappeared, another woman was running through Hines Park in Livonia. It was daytime. The trail was familiar, the kind of place where people jog to clear their heads, where danger isn't supposed to live. She was alone, but not isolated. And then she wasn't alone anymore. As she ran, a man appeared behind her, not charging, not shouting, but close enough that when he reached out, she didn't have time to react. An arm came around her neck, her balance broken, and suddenly, the trail disappeared behind leaves and branches as she was dragged into the woods. Now, according to testimony later given in court, he restrained her, struck her, and demanded sex. But she fought. She screamed when she could. She struggled when she had breath. And when the force around her neck loosened, she did what many victims instinctively do. She spoke. She told him she had a family. She told him she had a daughter. She begged him to let her go. Now, at some point, the attack stopped, not because the injuries weren't severe, because they were. Medical exams later documented injuries to her head, neck, arms, legs, and back. Evidence of strangulation. Evidence of blunt force. But she was conscious. And when she saw an opening, she took it. She ran out of the woods, back toward the road, toward noise, toward people. She flagged down a passing motorist. She called 911. And because she did, because she survived, the system was able to respond. Now, DNA was collected, her injuries were documented, an investigation moved forward, and the man who attacked her was identified. Now, he would later plead guilty to multiple felony charges: kidnapping, assault with intent, and sexual offense-related crimes. He would be sentenced to 16 to 35 years in prison. Now, she lived. There is no public statement explaining why he left her, no confession describing his thoughts, no quote revealing intent. What we know, what the record shows, is that the attack was violent, sustained, and interrupted. Interrupted by resistance, by her voice, by her refusal to disappear quietly.
And I appreciate that she survived. And she survived because she kept fighting, thankfully.
Absolutely, and that matters. Because this woman's survival becomes part of the larger story. Not a comparison, not a prophecy, but as context. A reminder of what can happen when an encounter turns violent, and what it takes sometimes to live through it. In the courtroom years later, lawyers would argue over whether this attack could be mentioned at all, whether a jury could hear it, whether it showed intent or risked prejudice. But outside the courtroom, there is no argument about one thing. This woman is alive because she escaped, and Danielle Stislicki never had that chance. The law would later debate whether this story belonged in Dani's trial at all, because in a courtroom, even survival has rules. Now, at this point in the story, it's natural to ask a question that feels almost unavoidable. If this attack happened, if it resulted in a conviction, why wouldn't a jury in Danielle Stislicki's case hear about it? And that answer lies in the rule of law known as other acts evidence. In criminal trials, prosecutors are generally prohibited from introducing evidence that suggests a defendant committed a crime before, simply to show they are the kind of person who might commit another one. The concern is prejudice. The law does not allow a jury to say, he did that, so he must have done this. Instead, prior acts can only be introduced for very limited purposes, such as showing motive, intent, absence of mistake, or a specific plan, and even then, only if the court determines the probative value outweighs the risk of unfair prejudice. In this case, defense attorneys argued that the jogger attack was too different from Danielle's disappearance. Different location, different circumstances, different outcome. Prosecutors argued it showed intent and capability, and the judge was left to decide not what felt relevant, but what the law allows. Because courtrooms are not designed to tell full biographies. They are designed to test evidence, carefully, narrowly, and sometimes painfully. This is why you may know more than the jury ever will, and why trials are not about truth in the broad sense, but proof within rules. Because from a human perspective, people naturally connect these cases, but from a legal perspective, that connection is radioactive.
Because it feels obvious when you talk about the two instances next to each other, but courts don't run on feels. Courts barely, in my opinion, work on common sense. So I get it, but it's not about the feels. It's not about whether you feel like they're connected. It's you have to prove that they're connected. I get it, but I don't get it, if that makes any sense. It drives me crazy. The legal system drives me crazy.
I couldn't agree more. There's a lot of weird-ass loopholes in there. The truth should be the truth. That's what I say. Present it. I get it, but I don't like it either. The Michigan law is extremely cautious about introducing bad acts. Again, the concern is prejudice, convicting someone not because the evidence proves this crime, but because the jury believes he's capable of it. So even though this prior attack shaped the public narrative and arguably intensified investigative focus, the court has been careful about how, or even if, it can be discussed at trial. And this matters because, for many listeners, that earlier crime answers the emotional question, could he do this? But courtrooms aren't built to answer emotional questions. They answer only one. Can you prove it? Cleanly, legally, and beyond a reasonable doubt.
Okay, so what's sticking with me isn't just that she survived. It's how she survived. She fought, she spoke, she refused to go quietly. And that matters because so many people are taught that silence is safer, that compliance will protect them. But this woman lived because she resisted in every way she could. And we don't talk about that enough. Survival doesn't always look heroic. Sometimes it looks messy, loud, desperate. But it's still survival, and it deserves to be honored.
I couldn't agree more, and I always think to myself, You hear these stories where they put a gun to you, come with me, stay quiet. Hell no, I would lose my shit right then and there. Nope. Because guess what? They're going to do something horrible to you anyway, so let's just get it over with now. And take your chances at running.
You might as well do something horrible back, is what I say.
Absolutely. I would rip those things right off someone in a hot second.
Yeah, but that's another thing, as we all always have that guttural reaction to, oh, I wish a bitch would, because I would XYZ. But you really never know what you would do until you're in that situation. So it's always easy to Monday morning quarterback something, but reality is what reality is. You know, you do what you do in the moment. And sometimes we are programmed to just not let it happen, but go with the flow and try to appeal to their emotions. But unfortunately, with monsters, they don't always have the emotions you think they're going to have. So putting up a good fight is the only way to go sometimes.
That's what I keep saying in my brain. I keep doing those mental exercises that, God forbid, I hope it never, ever happens to me. But I'm a fighter. I'm not going down easy. No way.
Yeah. And hopefully, eventually, everyone will feel that way. And we'll get to the point where this isn't so easy to do.
Exactly. Now, Dani vanished in December of 2016. The murder charge was filed in 2019, and the case becomes a maze of hearings, motions, appeals. Years passing with no jury seated. In February of 2025, Dani's parents spoke publicly after a pre-trial hearing, still waiting, still pushing for resolution. Then in May of 2025, courts set a trial date for February 2nd, 2026, with expectations of continued pretrial motion practice. And by late 2025 reporting, Dani's case is still listed among Michigan's major cases to watch in 2026, because after all this time, the state is still trying to put this before a jury.
You know what's really horrible is when you think about the family. The family literally has waited a decade just pending, living inside pending for a decade, for all that time.
It's absolutely heartbreaking. I don't know how you do it without it changing the chemistry of your entire life. The jury hasn't heard the evidence yet. But with the reality of what this case is now, it's not only a disappearance. It's also a legal story about what happens when cases' strongest trail may be locked behind courtroom doors. A jury selection, also called voir dire, will be one of the most important moments of this trial. Jurors will be asked, have you heard of Danielle Stislicki? Have you followed the case? Can you decide based only on what's presented here? They will be instructed to ignore everything else, and that includes things the public has discussed for years. Now, at the end of the trial, jurors won't be told to decide what probably happened. They'll receive jury instructions, legal rules they must follow. They will be told the defendant is presumed innocent. The burden of proof rests entirely on the prosecution. Circumstantial evidence can be considered, but must convince beyond a reasonable doubt. Sympathy cannot be a factor into a verdict. Jurors are not truth seekers. They are rule followers, and that distinction matters. The prosecution must build a case using what remains: opportunity, last seen testimony, behavior, absence of voluntary disappearance. The defense needs only to introduce doubt. There's no body, no direct eyewitness to a crime, gaps in timeline, missing evidence. Both sides will argue legally correct positions. Only one needs to convince all 12 jurors. Now, while lawyers argue doctrine and precedent, Dani's parents wait. they've waited through years of delays and hearings and appeals. And in February of 25, they spoke publicly, not with rage, but with exhaustion. Their daughter is frozen in time, and no verdict can restore what was taken.
I'm just going to say, justice doesn't always feel like justice to me.
No, it doesn't. Sometimes it just feels like the end of waiting. Now, a verdict will answer one question. Did the prosecution meet its burden? It will not answer where Dani is, how her final moments unfolded, and whether every truth was heard. This case asks us to sit with discomfort, because the law isn't designed to tell perfect stories. It's designed to limit power. And sometimes that limitation costs us certainty. Danielle Dani Stislicki is still missing. Michigan remembers her. And when this trial begins, justice will not be loud. It will be careful. Now, if you live in Michigan, this case feels close, even if you never met Dani, because she didn't vanish on a remote highway. She vanished between work and dinner, inside the geometry of normal life. And maybe that's why people keep saying her name, because saying her name is a refusal to let missing become background noise. Dani's story is, in many ways, a story about modern disappearance, how quickly a person can be swallowed by minutes, and how slowly justice moves afterward. Now, if you have credible information about Danielle Stislicki's disappearance, or believe you know something that could help investigators, please contact the Farmington Hills Police Department Command Desk at 248-871-2610. You may also share tips anonymously through Oakland County Crime Stoppers at 1-800-SPEAK-UP or 1-800-773-2587. And to learn about other ways to submit tips, you can visit the Michigan State Police tip page online. Now, if this story brings up memories of trauma, or you or someone you know needs support, the National Sexual Assault Hotline is 1-800-656-HOPE or 4673, and the 988 Lifeline in the U.S. are free. Confident resources available 24 hours a day. Now, this case asks something uncomfortable of all of us. It asks whether justice delayed can still be justice, whether truth survives procedural failure, whether a jury can ever see enough when so much is locked away. And it asks something else, too. How many times can a family relive the same moment, the same parking lot, the same unanswered dinner reservation, before time itself becomes another loss? Danielle Stislicki has not been forgotten. Michigan remembers her. And when February 2nd, 2026 arrives, the world will watch, not for spectacle, but for resolution. Until then, we say her name, Danielle Stislicki.
That's a rough one. A whole decade of waiting. I sure do hope that enough comes out that the family at least feels like they're feeling the story is being told. And they get enough. And, I always want to hold out a little bit of hope that maybe through the trial, things break in a way where he just cops to it and tells us where she is. I like to focus on the best case scenario and hope it happens.
Me too, and I really hope that, whoever it is out there that knows something, like maybe that cab driver, maybe he'll call in a tip, do something on your own to help this family finally receive justice for a light that they've lost. I couldn't imagine waiting a decade for justice for my daughter.
She could have disappeared on her own accord. It's not likely. It doesn't seem like it. But she could have. in the realm of possibilities always living on a spectrum as it is, there's always an alternative path this could have taken. Not likely, though, which is why I get so annoyed with suppression of evidence, because of the, all of the poison tree and all the fruit is susceptible to that same poison. The thing is, and then you mentioned how the cab driver, maybe they'll come through. The thing is that the whole cab driver and that whole cab scenario, we don't know if it was Dani or if it was the supposed attacker that had the cab ride. But even if they did come forward with more information, that whole cab ride has been suppressed.
Yeah, I wonder if, on that same scenario, if that cabbie called in, would that still be suppression because it's coming directly from that particular person? I wonder if they would tie it in. I hope not.
I don't know.
I'll wish for the good in humans who know something to come forward and say something. I mean, what if this was your daughter, your best friend? It's horrible. It's a horrible situation.
It is horrible.
Yeah. So we'll definitely be following this case in February, and hopefully they move forward and select a jury and move forward with this case. And I hope that the prosecution can do its job. So that's all we've got for you guys. Stay tuned for updates in February. So thank you, everyone. Thank you so much for listening. Follow us on TikTok, where we do short little videos of the storyline, but always come back here to get the full story. So thanks, everyone. Have a great week, and we will see you back on Wednesday for Round Robin. Have a great week, everyone.
Bye.
Bye.